Chapter 3. Misconduct by notaries, public or others relating to notarial acts. Misconduct by notaries, public, or others in connection with notarial acts may be addressed through criminal, civil, or administrative laws and proceedings. Criminal misconduct may be a felony, misdemeanor, or infraction. A felony is punishable by a term in state prison or county jail. A fine may also be imposed in addition to any imprisonment. A misdemeanor is punishable by a term in jail, probation, a fine, or all three. An infraction is punishable by a fine. Criminal misconduct may result in the revocation, suspension, or denial of a notary public's commission or application. Civil misconduct subjects a notary public to fines and may also lead to suspension or revocation of the notary public's commission or denial of a notary public application by the California Secretary of State. California Government Code Section 8214.1E. Also, a notary public and the sureties on the notary public's official bond are liable in a civil action for all the damages sustained from a notary public's misconduct. California Government Code Section 8214. Administrative action can be taken against a notary public or notary public applicant to suspend or revoke a notary public commission, or deny a notary public application for failing to discharge the duties and responsibilities required of a notary public. California Government Code, Section 8214.1D. Part A. Conflict of interest. A notary public who has a direct financial or beneficial interest in a transaction cannot perform any notarial act in connection with that transaction. California Government Code Section 8224. Best practices tip. Since California is a community property state, it is important for a notary public to exercise great care when performing notarial services for a spouse or domestic partner in order to avoid potential conflicts of interest. Section 1. Financial transactions. If a notary public is named individually as a principal in a financial transaction, the notary public has a direct financial or beneficial interest in the transaction and a conflict of interest and cannot perform any notarial acts in connection with that transaction. California Government Code Section 8224. For example, if the notary public is named as a party in a contract or is assigned the proceeds of a sale, the notary public has a direct financial conflict of interest and must not perform any notarial acts in connection with the transaction. Section 2. Real property. In the area of real property, a notary public has a conflict of interest if the notary public is a grantor, grantee, mortgagor, mortgagee, truster, trustee, beneficiary, vendor, vendee, lessor, or lessee in the transaction. California Government Code Section 8224. For example, if a notary public is a grantee of a deed of sale for a house or is assigned rents or is paying off a home mortgage, the notary public is prohibited from performing any notarial act in connection with that transaction. Section 3. No conflict of interest if acting for someone else. If a notary public acts as an agent, employee, insurer, attorney, assuming the notary public is admitted to practice law in California, escrow or lender for another person who has a direct financial or beneficial interest in a transaction, then the notary public does not have a prohibited direct financial or beneficial interest. California Government Code, Section 8224B. In other words, a notary public acting as an agent for another person can perform notarial services, or if a notary public works for a company that will receive benefits or money from a transaction, the notary public can perform notarial services in connection with that transaction. The notary public is not benefiting directly. even if the notary public's employer receives a benefit.